Thank you
Okay,
so much.
okay.
Okay, we're going to introduce Harold Franklin. Here we go.
All right. So anyway, like I was saying, it's always a good thing to want to learn these things, especially before the emergency hits. Most people don't like wills, and you're not the only one. I was at a will seminar with lawyers, only lawyers, and they asked us in that seminar, how many of you have a will? And of the 30 to 50 lawyers, maybe 4 had a will. And these are lawyers who can actually do it on their own. So people don't, for whatever reason, and I know the real reason is people don't like to talk about dying. But the reality is death is undefeated and everybody has to go. So we just need to be prepared for it. And so that's really what this is designed, is to prepare us for that inevitable event that's going to hit us. I hope to live, I always tell my congregation, I hope to live to be 120 years old, but if I don't, I want to be ready to take care of my family if I'm not here. And I'm the only one that works in our house. So, and that's always the way it's been. So obviously I have to take care of a larger group, well, my wife and I are the only ones left, but still. So with that in mind, I want to talk about the Washington State process of wills and trust. And I sent to the group some samples of a will, a sample of a power of attorney, sample of what's called a transfer on death deed, and also a sample of what was the other thing? I think it was a healthcare directive. And those things, I think they're going to make available to you after the seminar. And the reason I did that is because a lot of people look online and you can't really find these things just generally online without paying for them a lot of times. And so I wanted to let everybody see what a will looks like. But the reality of it is wills are very simple documents. The requirements are not that lengthy. To do a valid will in the state of Washington, it can be handwritten if it's only dealing with personal property. Personal property means that property that's not real estate. That's what it's for. That's what personal property is. And if you have real estate involved, the will has to be typed and written out. Of course, they don't say typed, but it has to be in a letter type. And that I think she put up on the wall there. So you see, that will is only 2 pages. He did have a real property interest in that he was given to his son, and therefore that's why he had to have it in writing. Then on top of that, the will has to be witnessed by 2 people, and they have to be 2 people that are not in the will. So it can't be, in this case, you see it's AJ or A. Phillips Jr. cannot be the witness. It has to be somebody that's not in the will, mentioned in the will. If you have a witness that's mentioned in the will, then that person cannot receive anything in the will. So that's very important. You cannot put a witness who is also on the will. That's usually where most people who haven't gone to an attorney, that's where they make the mistake. They have the beneficiaries listed as the witnesses. And the reason why they do that, and I know you say, wow, that's pretty harsh. Well, the reason why they do that is they don't want to have the beneficiaries be the ones that are directing the ship, so to speak. In other words, they're trying to get them to give them stuff, and then they're trying to also be the witness of the will. So the statute separates the beneficiaries from the creation of the will, so that there can't be any assumption that there was some bad acting going on. And that's basically why. The other main thing that comes up is that anybody who is appointed as the executor, or now it's called a personal representative. If you have a will, it's called an administrator. If you don't have a will, and we'll get into that in a minute, that person cannot have a felony, and they cannot have been convicted of a crime that's involved what's called moral turpitude. Now, this is one of those legal terms that I still can't really figure out what it means. But what I've come to know that, number one, if you've been convicted of fraud, if you've been convicted of counterfeiting, things of that nature, theft, but it's not usually minor thefts, it's like major thefts, murder, obviously, things like that. Those are crimes involving moral turpitude. And so anybody that has a conviction, a felony conviction or a crime involving one, and that's not obviously the exhaustive list, but that's just an example of a few things that include moral turpitude. And so once you get those things out of the way, you get the two witnesses, you get your administrator, which is also called, like I said, a personal representative. Some people call them executors in the will, but the actual term that it becomes is personal representative. Then all you have to do is have it signed. And as you can see, it doesn't have to even be notarized. It just has to be signed, and then you put down where the witnesses are located. Now, what I do in my wills is what's called a self-authentication document. And I don't know if I've gave you that page, and it's usually a third page to the will. Oh, okay, it is there. Okay. So what this does is, the reality is that when you do a will, what could happen? Well, some of the witnesses might be dead, right? So they're not going to be able to come to the court and say, hey, I knew Harold. I saw him do his will. Harold was of sound mind when he did his will. And, boom, that's the end of it. So what you do is you do what's called an affidavit of attesting witnesses. And you have them fill out this affidavit. And on that, the witnesses sign it. They print their name. And then they don't have to ever show up at court. So this will is filed when the will, or excuse me, this document is filed with the will when the person passes away. And then the will is self-authenticated, which means everybody says that they're of a sound mind, they knew what they were doing. I saw them sign it, etc. And I'm not around or I can't be found. And therefore I'm using this in exchange of my testimony. So that's kind of a preemptive strike, if you will, to keep wills going so that you don't have to find the witnesses on the will. It's a pretty important document because it is, the reality is some of the witnesses don't stay around. They move, they do die, obviously, or they may become incapacitated, which means they couldn't testify at that time. So you do this while everybody is lucid and understanding and know what's going on, and therefore you don't have to worry about it. And this usually stays with the will, and therefore, the will takes care of it. Now you can see that that document is pretty simple. Now, the other thing about a will is, well, let me back up. Let me start here, because a lot of people think that a will is necessary. But really, when you're dealing with an estate that's not that large, and most of us are dealing with houses. I mean, most of us have a house. Maybe we have two houses. You really are thinking about how can you provide for your heirs, if you will, or your children or your grandchildren. So if you don't do anything, if you don't ever get a will, the main thing, and I'm not an insurance salesman, but you should get some kind of form of life insurance. And there's a couple of reasons for it, and obviously they're obvious, but the number one reason is life insurance will pay for your burial, okay? Because as everybody knows, burials now can run depending on where you go and what kind of burial you have, anywhere from $2,000 all the way up to, well, really however high you want to go, basically. But the normal ones usually run from about $2,000 to $15,000. And that's, if you don't have that money just laying around in your bank account, that's a big chunk to have to come out, and they want it up front most of the time. So if you have life insurance, they'll hold off on the, you got to have the money now kind of pitch they give you. And the life insurance, once that's resolved, once the death certificate is given and all that kind of stuff, then you can take it out of the life insurance. And then secondly, of course, if you have life insurance, you can name the beneficiaries and the money will go directly to them. Now, let me say this about life insurance. And again, I'm not a life insurance agent, but this is something lawyers most know. Life insurance is not covered under the will. It's what's called a contract. And it's a contract between the insured, which is going to pass away, and the beneficiaries. So you don't have to mention life insurance in the will, because it's what's called an asset that is resolved outside of the will. And so you just have to make sure that you name the right beneficiaries, because a lot of times what happens is somebody gets life insurance, they got it when they were 25, and the beneficiaries have grown up or whatever, you've grown up, or you don't want to give it to so-and-so, or, well, I'll give you an example. Let me give you a bad example, but this is what happens. So you got it when you were married. You married somebody, the spouse was the beneficiary, and then all of a sudden either the spouse dies or you get a divorce. You get a divorce and you don't change the beneficiary's name. Guess who gets the money? That spouse that you divorced. And the insurance doesn't care who gets it. They just have to follow the contract. So you have to make sure you update your beneficiaries regularly so that the people you want to get the money. And that's very, very important. But so if you don't do anything about wills and all this stuff, you should at least get some life insurance, okay? And you might say, well, how much life insurance should you get, right? That's the next question. Well, the old rule is you should get 10 times the amount of your annual income. That's just a rule of thumb. Now, so if you make $100,000, that means you should have $1 million worth of life insurance. If you make 50, you should have 500,000, and so on and so forth. Now, that's just a rule of thumb. It's not a requirement, but that's just a general idea of what you should do. All right. So that's the insurance thing. Let me back up to about why wills are necessary. Most people talk about wills, but there's other ways, and we'll talk about trusts in a minute. But wills are so that you can control who's going to get your property. I think Geneva mentioned people want to leave legacies. This is where most people refer to as leaving a legacy. And this legacy is a material legacy. I think there's a number of different legacies that you want to leave, but this is the material kind of legacy, monetary or whatever, or property legacy. So a will helps you to control where your property is going to go to. And let me say this about giving things to your children, grandchildren. Most of us like to be fair and say, well, I'm going to split it evenly, but let's be honest with each other, and let's be honest with ourselves. Every child, every grandchild doesn't have the same amount of maturity and responsibility. Everybody should be nodding, right? Every child doesn't do money right. Some you wouldn't give $20 to, let alone 20,000. So you have to be careful about, and that's mom and dad. They always want to be fair. Everybody wants to be treated fairly, but fairly sometimes means that you've got to let their kids grow up. And so what I did, and just give me an example of how I did my will. I had two sons that kind of went south. I mean, they're kind of coming back, but they went south as far as we were estranged. We didn't really talk to each other. So I gave right now the property to my oldest son, and he can live in it. But if he sells it, then he has to share the money with his brothers. Now, they might be mad and say, well, how come he gets the house? Well, so you figure it out. But that's what you have to do sometimes. And don't be afraid to do that. It's your property. I know kids think it's theirs, but it's really not. It's yours. You were the one who paid for it. You were the one who's been paying it off all these years. So don't let them say, well, this is mine and this no, not yet. I'm still here. This is still mine. So don't be afraid to divvy up the property according to the responsibility that you know your kids have, and be honest with yourself. Don't try to say, well, Johnny and Jim, they're my two boys and I love them, but Jim is not very responsible. Jim never does anything you tell him to do. Every time Jim gets an opportunity, he's going the other way when you'd want him to go the other way. So Jim probably doesn't need to get some of the same, or you can do it where Jim can get it in increments. So just remember that. So that's the purpose of a will. And then there's what's called a living trust or trust. Now there's 4 types of trusts. Well, actually, they're not really types, but there's 4 ways that trusts can be created. There's what's called a revocable trust. Anybody know what the word revocable means? I guess you can't talk to me because everybody's muted. But revocable means you can change it, okay? And most trusts that are created are changeable or revocable. You can change it all the way up until the day that you die. And then there's what's called a living trust, which is pretty self-explanatory, which means you created that trust while you were alive. Then there's what's called the testamentary trusts, which is a trust that's created at your death. And then there's the irrevocable trust, which means this is a trust that you cannot change. Now, for the most part, most of us want trust that we can change. The reason why you would do it, what's called an irrevocable trust, it's usually dealing with tax issues. And so in order to avoid a tax issue, you create a trust, you put the property that would be taxed in that trust, and you can't reverse it because you don't want to pay the taxes. Now that's just a general example of why. And you just can't go back and change that trust. Now they say that, but of course, lawyers always find a way to undo what they say can't be undone. But for the most part, you can't change an irrevocable trust. But like I said, most of us, if we're going to do a trust, we're going to do it as a revocable trust, which means you can change it. Now, so
Excuse me, Harold, I have a quick
Sure.
question. So what is the difference then between a will and a trust? Because what I hear you saying is that a trust, would you also dictate how you want your monies or properties? Let's say you don't have property, but you have a large sum of money in the bank.
Right.
And so how is that viewed if maybe you have one of your children's names on that account and not the other?
Right.
And you want to have that money, though, equally divided amongst your children and your grandchildren or whatever. So I'm trying to understand the difference between the will and what the living trust is.
Yeah, and I was going to get to that.
And then
so
if you
thanks
have large sums of cash versus property.
Right. So if you have large sums of cash and you only have one child on it, that's going to be a problem because they are on the account that technically they own the account. They're joint owners of the account. And bank accounts, let me back up a little bit. So bank accounts, I mentioned life insurance is not under the will. Bank accounts are not under the will. Retirement accounts are not under the wills. Investment accounts are not under the will. So all those are controlled by contractual beneficiary pronouncements, which means you have signed your account card and you said, if I die, so-and-so gets the money. You do that when you open the bank account. Everybody remembers that? It's called what is it called? I can't remember what it's called now. But you declare a death beneficiary to your bank account.
Right, or a second signer on the account. Like sometimes you may, for many of us as seniors, if I couldn't get to the bank, I have my son as a second signer where he could go into the bank and handle and do my banking if something happened.
Exactly.
Okay.
But if you were to die, that money would go to him. So you could, in your will, say that the bank account that I have and I'm sharing with my son, should be split evenly amongst my other children. You can say that in the will, but the bank is only bound by whatever the beneficiary has. Now, he's supposed to do that in the will, but he can raise up a fuss and say, nope, this is my account, I'm on the account, this is my money, and so on and so forth. And I know you say, well, no, he's not going to do that. He's wonderful. Listen, I've seen it all. So it could happen. I hope it wouldn't happen, but it does happen. So you can just do that. So let's go back to the trust. So the difference between a will and a trust is a trust document is a document that you transfer your property in presently. And everybody always hears about, well, trust helps you avoid probate, right? Everybody heard that before? If you have, raise your hand. And we'll get into probate in a minute. But a trust, the reason why you avoid probate with the trust is because you transfer the property out of your name. So a trust is a document that holds your property for the benefit of who you name as your beneficiary. So there's three people involved in a trust. Okay. There's the trustor, who is the one who creates the trust. There's the trustee, who is the one that manages the trust. And then there are the beneficiaries. Now, all three of these groups can be one person. You can create the trust, you can manage the trust, and it could be for your benefit. Okay, so and there's no rules that prevent that. A lot of people do that, and a lot of it is for liability purposes. They get the property out of their name and into the name of the trust, so nobody can sue them and take their property, etc. So that's why it doesn't have to be transferred. See, the main reason why you do probate, and I'm getting ahead of myself a little bit, but not too far, is you usually have to transfer property from the person that has passed away to the heirs that are supposed to receive that property. Okay. So that's the main reason why you do a probate. Personal property. Yeah, I see your hand, but let me finish the sentence and I'll let you. A personal property can transfer without the probate process. So if you have a car, you can get the death certificate, you can transfer the car out of the dead person's name and into the living person's name. All the other things you can transfer, you just give people the stuff. But property has to have a writing, and therefore only the living people can transfer the property. So Geneva, go ahead. You had a question.
Oh, I was gonna let you know, we have 4 questions.
Okay.
I think first was Grandma Rose, then Gertie, then I believe Debret, and then Sharon Idner.
Okay.
So Grandma Rose, do you want to ask your question?
Yeah, this is one that just came up recently. I got a bunch of questions, but this is when I was going on to the unclaimed money on the revenues page.
Mhm.
And on my when my in-laws passed, both of them passed like within a month of each other. And so there was a lot of stuff to be done with the lawyers. But there
Okay.
was all sorts of unclaimed money from like 500 and more from different trust accounts or just different trust companies with mortgages and all this. I mean, just lots and lots of unclaimed money in the hundreds or other, like it'll say 500 and above.
Right.
And so I tried to reach out to my ex-husband who's currently, suffering from MS and not really stable in housing and stuff. I couldn't get in touch with him. And so I got in touch with his sister, who's actually on, because of his medical conditions, they didn't give him anything, right? Like any power.
Mhm.
So then I contacted her and she was so happy because she gets to claim anything, any legal money or any money and it doesn't go into a trust. But I don't know. I didn't say anything, mention anything to him about it, but I probably should have. But does that money after the fact? Because okay, you don't need the remote. But the money after the fact that wasn't dealt with the lawyer and she's still the beneficiary, does she get claims to all of that? without having to split? Just two siblings, thank God.
Yeah, well, that's a good question. It's hard to know because it depends on who the property was in the name of. If it's in the name of the deceased person, you usually have to have the administrator get it, or at least make the application to get it.
Yeah, you have to
But-
apply for it, and it's
Yeah, so
both of
once
the
you,
parents.
yeah, so once you do that and they give the money to you, if it were me, I'd split it anyway, just to keep the peace of the family, because let's face it, peace of the family is better than a few extra dollars. But I don't know if the will doesn't obviously control if the probate is closed. But I think if it's something that, if you feel that you should share it. It's just a good thing to keep the peace among siblings. I'm all for peace above money. Because money will always come, but peace can be destroyed. So that's kind of my philosophy of life.
Thank you. Thank you.
Okay,
Gertie
Another
is,
question?
yeah, Gertie's next.
okay.
So I'm thankful that I get to listen to your great advice this morning. I have a couple questions.
Okay.
A little over a week and a half ago, we had a death, and that is my ex-husband, the father of my children. We were divorced, but we have known each other since we were 20, and we were good friends. Anyway, so the couple of questions, some of the family members, so there's no will. We have to try to figure it all out, what's what. As far as bank accounts, especially credit cards, some family members Googled, whatever that's worth, that family does not have to pay credit card debt because it was only in his name and he was not married.
And that's your question?
Yes, yes.
Yeah, so that's the other reason why you do a probate. The probate only it pays the debts of the deceased. So you're right, they technically cannot, if you're not on the account, they cannot collect that from a non-deceased family member. But usually what you have to do and we'll actually get into the next section is about probate and with or without a will. So we'll touch some of this, but once you file a probate, you have to do what's called a notice to creditors. And then that's when you find out if people owe credit card debt. But if there's nothing in the estate to pay, then they don't get anything. So that's kind of the way it works.
Okay, I have another quick question. We have two daughters.
Mhm.
So how can they transfer the vehicle over into one of their names?
Yeah, so you take the death certificate to the Department of Licensing, and then they usually have a form that you fill out and then you transfer it that way.
Thank you very
But
much.
you have to have the death certificate though.
Okay, that will be available next week. Thank you.
Okay, you're welcome.
And Debert is next.
It's the bread. My question is, if you're leaving big lump sums of money to family members and you don't want them to pay the taxes on it, what do I need to do in my estate? Do I need to take that, the money and put it in trust funds? Do I need to set up trust fund accounts? I'm just trying to keep it where they don't have to pay taxes.
How much money are we talking about? Over $2 million?
Oh, so if it's 2 million, so if it's under 2 million, I don't need to worry about it?
Right. You don't.
Okay,
That's in Washington. I think the number in federal taxes is like 11 million. So
Okay.
if you're not that high, you don't have to really
don't
worry. about
worry. Okay,
Yeah.
And Sharon is next.
thank you.
Yes.
You're welcome.
Thank you. Harold,
Yes.
the banking term, if you have one of your children on your account, is they call that survivorship.
Yes, thank you.
And
I was having a senior moment. Thank you. For that.
also vehicle.
Rights of survivorship. It's actually
Yeah,
called.
I have that, my one son who's basically going to become our executor
Mhm,
because we adopted grandchildren too, so they're our children.
right.
So. Okay, that was it.
That was it. Okay. Well, thank you. Thank you for that,
And
helping me there.
so somebody had a question. Do you have to put all your children in the will or can you leave someone out?
No, you can do whatever you want to. You can leave them all out if you want to, but you have to name them, and then you have to specifically say, and even though I have 4 children, I don't want to give any of them anything under this will. Because otherwise they assume that you just left them out by mistake.
And somebody else had a question. Does somebody do background checks? I'm
For-
assuming,
for
I'm
what?
assuming that has to do with when the person who's in charge of the will.
You mean to find out whether or not they've been convicted of a crime?
Yes.
Yeah, the courts will do one.
Okay.
In Tacoma, they do it right there. I think they all do it. But when you apply to become the personal representative or the administrator, you have to declare that you don't have a criminal history. So if you lied, then they can remove you.
Okay. So we have a couple, 3 more hands up.
Well, let's move to the next one, and then just hold your question. I'm going to go to the next section, and maybe this will answer some of these questions.
Okay. Sounds
So then you have the situation where there's no will. If you don't have a will and you have to transfer property, you have to file a probate. This is what's called intestate succession. A lot of people believe that if you don't have a will, that the state will get your property, and that's not true. The intestate system, there is a system. So it goes to your spouse if you're married first, and your kids. And if there's no spouse, it goes to your kids. And if there's no kids, it goes to your relatives, like brothers and sisters. And it keeps going down the line. The only time the state gets the property is that there's absolutely nobody in your family that's still alive that can take the property. So a lot of people hear stuff like that and they say, oh no, if I don't have a will, the state's gonna take. That's not true, okay? That's one of those urban myths that is not true. So I'm here to dispel that myth. So now, once you do, if you don't have a will, then you do have to file a probate if, and there's always the if, you have real property or a house, okay? Because that's the only way you can transfer the house out of the person that has died's name. Now, there are ways to transfer property out of the dead person's name before they die. And that's one of the documents I gave you. It's called the deed on death transfer. So she's gonna try to pull that up. And that was a go back, that was it. So this is a transfer on death deed, I'm sorry. And this is something that they actually allowed, I think it was about 2015 or 2014. And so what you can do now is you can name who you want to give your house to before you die, but it doesn't come into effect until after you die. So this basically removes the reason for probate if you do this deed. So and then what happens is the person that you declare to get the property should hold on to that deed. Once they get the death certificate, they file that deed with the death certificate. The records department transfers the property into the name of the person that's supposed to get it, and that's it. That's the end. And so now your property has been transferred. So that's another way to get property out of people's name, like a trust. Like I said, a trust transfers the property before they die as well. That's why they don't have to go to probate. There's nothing to transfer because it's all in the trust. And then this deed also allows people to transfer their property before they die. and therefore doesn't require a probate to do that. Now, again, we still dealing with, you still may have creditors to deal with, and some people might say, well, what about mortgages? Only issue about a mortgage is when it's what's called a reverse mortgage. Those are mortgages that are due on the death of the person who took the mortgage out. So those mortgages usually have to either be refinanced or paid off, or the house sold to do whatever to take care of the mortgage. But if it's just a regular mortgage, then it doesn't have to be paid off. The person that inherited the property just has to start paying the payments, and there's nothing they can do to make it so you have to pay the mortgage off, as long as it's current at the time. So that's another way to do. So the probate process, and if I didn't answer the questions, go ahead and ask the question that you wanted to ask.
Oh, I had a question, Harold. Just, is it the old myth, as you were saying, that you don't have to leave anything to your children? People used to say, well, if you leave them $1, then they can't contest the will. Is that true?
No, but you can always, in your will, you can say if anybody contests the will, they don't get anything. So you
Oh,
can
okay.
say that actually in the will.
Oh, okay.
And some people have done that. But some people do leave $1, just say that so that they know that everybody knows that they didn't forget them. But I would not encourage anybody to, unless, there's a good reason to not give your kids something. I would never encourage anybody not to give their kids something, even if you gave it to them before you died. But make sure, because again, once mom and dad are gone, it's just the children, and now they have to learn to get along. And there's always sibling rivalries brewing anyway. So don't foment more sibling rivalries when you won't be able to be there to referee it. So be careful when you just want to cut people off, unless, like I said, unless it's something that you just, there's nothing you can do about it. But like I said, peace over money is the key. What are the other questions that you said there were
Okay,
about
so
3 or 4 questions?
Yeah, Brenda has a question.
Okay.
Hi, you might have already said, well, I have 2 questions. You might have already answered it. Maybe I didn't hear it. The difference between a living will and a living trust. And you were saying something about that deed on death transfer. Is that something that, how do you get that paper?
Well, I gave you one, so you'll have one. That's what it looks like. So you can use that one. You just have to obviously tailor it to what you need to do with it.
Okay,
But a living will is not a will. It's usually a pronouncement of what you want people to do with you in the event that you cannot say what's wrong with you, and therefore you can't tell them if you need treatment or not. So a living will is kind of a misnomer. It's more of a last death instructions document, but they do call it a living will. And I think I gave you a healthcare directive, and that's really what a living will is. And there's also a form, the new form that I just saw. It's the abbreviation is POLST, POLST, and that's the same thing. And I think you can get this from the doctor's office. You can tell them how much treatment you want. You want them to do full treatment, partial treatment, or no treatment. There's a box to check. They have you sign it, and they keep it on record. So that's what a living will is. So a living trust is, like I said, a trust that you create during your lifetime. But living wills is not, that's not, but you can change a will anytime you want to. So
okay.
I hope that
Okay.
answers your question.
And you said you sent us that thing about the
The deed on
Yeah.
death, that we were just, we were looking at it, and they said they're going to give you these documents afterwards.
okay,
So
good.
there
Thank
will
you.
be one on available once this.
Okay, yeah, thank you so much.
You're
And you can
welcome.
add that to your will anytime. If your will is already made up, you can add that in there.
You mean, it's not added to the will, it's a separate document,
Uh-huh.
but you can do that anytime, of course.
Okay, great, thank you.
You're welcome.
I have a question about that death deed of trust. Can you do it by yourself, or do you have to use an attorney? And do you have to file it on the court?
Well, let me say this about, you never need an attorney to do anything. There's nothing, there's no law that requires you to have an attorney to do anything, okay? That's the first thing. If you feel that you are savvy enough, experienced enough, you can do anything by yourself, okay? But in order to do the deed transfer on death deed, you have to have it signed by a notary. All property documents have to be in writing, and usually they have to be notarized. So this deed, so you can fill it out by yourself, you can sign it, but it has to be notarized in order to be valid. So you'll need at least a notary to finish the deed, but you can do it yourself, absolutely. Usually what you, the hardest part about a deed is you have to find the property, the legal property description to enter into the deed. And most people get that from, you can find that on your tax statement. Usually there's a legal description of the property that you live in on your real estate tax statement, but that's not the complete legal description. And so, well, now the records department is closed, so you have to do everything by mail. But if you were to walk in the records department with that abbreviated legal description, they will say, no, you need the full legal description. And then you ask them, well, where do I get that? Well, then you have to either go back to an old deed and copy it, or you have to pull up some kind of document that has the full description. So that's the only problem with doing things by yourself. You just have to know where to go to get it. And the reason why lawyers get money, because they usually know where to go to get it. That just makes it easy for everybody. So, but absolutely, you can do it by yourself without any lawyer's help.
Jody has a question.
Okay,
I will say, I don't have a will, and obviously I'm super old. I have 9 children.
okay,
Seven of them are adopted. 3 of them are still minors.
okay,
Some of them I'm very estranged from, and and honestly, there's certain children, at least at this point, that I don't want to even let them know I'm dead. Now, my understanding is that if I that I have to put them in the will and say I'm not leaving them anything. But then I also heard that if I put them in the will, they'll be notified. So
well, they're gonna, go ahead, I'm sorry.
is that true? Because I'm kind of battling with, I mean, these are
Well,
people.
let me answer.
People
Let
won't
me
even know
answer your
I was
question.
dead. It won't be contested a will because I
Right,
don't hear from them.
yeah, well, if you die, then somebody's gonna know you have all these children, and all heirs have to be notified of if a probate is started. So if you don't have a will, and do you have a house?
Okay, so if I transferred the house into that trust, then I don't have to go through probate and they won't be notifying anybody?
No, they'll still notify them, but
Mm.
because they have to know about when there's a death. So yeah, I mean, there's no way that they wouldn't know unless they couldn't find them.
Some of them can't be found, but
Okay, well, then they probably won't be notified.
yeah, there's just people I would rather,
Not know,
because
huh?
they're very nice.
Okay, I understand.
Thank you.
You're welcome. Was that all the questions?
No, there's somebody wrote in the chat, can you have more than one executor on the will?
Executor, yes, you can. But the problem that you run into is what happens if they start disagreeing. I had a will, well, actually it wasn't a will. I had a probate that I had to do, and I think it was in Lewis County. And the person didn't have a will, but the 2 cousins were appointed as the administrators of the estate. But in order to be able to do things without having them both to agree with it, I said, well, one administrator can decide for the estate, especially if one is not available. So you have to make some kind of a provision to get over the deadlock in the event that there may be one. I did have a will where there were two executors. They worked out pretty well. They didn't disagree. So if they get along well, then okay, that's okay. But I would make them alternate executors, which means if one doesn't want to do it, then this one can be the other one, the executor. But it's unless they really need to and they want to, maybe, I mean, twins are like that, they do everything together, so they might want to both be an executor. But I would try to avoid that if any, like I said, unless you know that they're not gonna be at odds with each other. Okay, is that all the questions pending?
No, there's, somebody has their hand raised, Vancella.
Is she there?
Oh, brother. Yeah, I'm here. I'm just driving down the street because what happened is this guy that he's no kin to me, but we've been friends for like 20 something years.
Mhm.
And he died, and he left what I thought was a living will. And now the bank and stuff, he has a sister that I can't get the money.
Okay. Again, remember, the rights of survivorship controls. So whatever is on the bank account at the time of his death, that's who gets the money. So it doesn't matter what he told you if he didn't change that at the bank. That's what the bank is going to do.
Oh, all right.
Okay.
All right.
Okay, but her name ain't on there either.
Well, somebody's name is, so that's something that they have to work out. And most likely, if it's only the money that's in the bank, there has to be some kind of what's called an affidavit. Unless, if it's less than $100,000, they have to do an affidavit in lieu of a probate showing that this is all the property he owned and it should go to this person.
That also goes for
So, yeah.
safe deposit boxes. When somebody passes away, if you're a legal husband, even though you're estranged, they still get access. They get action for that.
Oh, wait. You said
If
you're
you're
married, but you're
estranged,
not
if you
together?
have any bank stuff and you're estranged from your husband and they die,
Yeah,
the spouse, if they're not legally divorced, gets action for that, for all the bank stuff.
they should, yeah.
So there's no question, but that's not my question. I have a father who, okay, so my mom and dad are divorced and they each are property owners, and one's in Florida with
Right.
his third wife, right? And my brothers and I and sisters are thinking
Yeah.
there's gonna be more debt. There's gonna be more debt with his death. So, and I was talking to him and I was asking him to make sure that we're not part of his debt, to make sure that that third wife is that fair that they can't put any of that stuff on us? Because I found out he's got like 3 storage units filled with stuff, like big storage units. And I'm like, man, I could just see the debt. And when he retired from a huge aluminum company, I knew that he has a lot of survivor benefits from that place and some other stuff, but it doesn't really matter. I still think that there's going to be a lot of debt with him.
Mhm.
So how do we make sure that we don't get any of that, that she gets it all, she and all her kids? So that's my hope and dream.
Well, you said he lives in Florida, right?
Yes, sir, he does.
Okay, so that Florida law would probably control the property if he owns property in Florida. But, you know, I don't know if he has a will or not, but any debt that is on your father's under his name at the time of his death, we already said that the estate has to pay it. So, you know, whatever he owns minus the things he owes is what gets given to the people that are beneficiaries under a
Oh,
probate or a
It
will.
doesn't just automatically go to her, like.
No, it doesn't. I mean, if he doesn't, it's hard to know because I don't know all the details. But I mean, if it's property that he owned before the marriage, it's his property. Florida is not a community property state.
Okay,
That's about all I can really say. If
so
he
I
has a
have
will, then he can will his own separate property to whomever he wants, but
okay, so I have another one with my mom is having liver failure right now. And my stepdad just had open heart surgery. I have a brother who's a drug addict that won't move off the property because he feels like when they leave that house and that property and everything that they have is his. And so him and his girlfriend won't leave. And I was thinking that we should probably just sell the house and the property and put them in assisted living. So we don't have to deal with that house thing. Because, and that trust, that transferred of deed, is that part of that? So it'll go into a trust? So we don't have to deal
no,
with the house
it's not
part?
going into a trust. The
Oh.
deed is just being transferred after the person has died. So the
after.
owner, it's not a trust thing, but it's a transfer of property so that you don't have to usually file a probate just for the sake of.
They got a
dealing with the
lot of
property.
stuff. That's what this
You're
is.
talking about your brother? Are you talking about the
No,
brother living in
my
there?
mom and my stepdad have a lot of stuff
Okay,
to leave. And the thing is, and he doesn't have any kids. We're his kids. And
okay.
so when those two leave, we don't want the property to deal with the property that they have. It's and we don't want to deal with my brother. So how do we X him out? I mean, we're not completely. I mean,
Well, is your
he's lucky
mother
he's
still
been living
alive?
there. Yes, they are, but as they're aging and the liver failure, and I've noticed because I just had her for like 10 days, she has a little bit of that dementia thing. So we want to make sure that she does stuff as sound of mind.
Mhm.
Well, she just had
Well,
you
yeah,
can
I
get
mean,
any
it's-
kind of infection and get delirious when you're old.
Sure. Well, there's a lot of issues there, but I think if you want the brother out, if she wants the brother out, she may just have to evict him, unfortunately,
Oh yeah, we've
and
tried.
then go from there. No, I'm
We've
not talking
tried.
about you tried. You have to go to the court and have him evicted.
Yeah,
Not
he
you
went
personally.
too. Strangely enough, a drug addict would go there and say, but isn't there a pandemic going on? Can't
Well,
force me out.
there was, but now it's over and now you
Oh,
can
yes.
get him
So they
evicted.
say.
So,
That's right. Thank you.
all right, you're welcome. All right, so we're going to move on from here and we can pick up some questions from there. So going back to the probate process. So the process of the probate is you file the petition to probate the will, if there is a will. You file, you tell who all the heirs are. You try to figure out what the assets and the liabilities are, which everybody's been talking about, bills or debts. That's what you do. You say whether or not the estate is solvent, which means there's more assets than liabilities, and therefore the estate is solvent. And then you ask for the court to appoint the executor / personal representative named in the will. Usually there's no bond requirement because in the most wills that are drafted, they remove the bond requirement. And then there's also what's called non-intervention powers, which means that you don't have to go to the court and ask for them to allow you to do things. You can do it without the court intervention, but the court can intervene if somebody thinks that you're doing something you shouldn't do. And that's the typical process. You file a notice to creditors. You have to give them 4 months to respond. And you don't need to remember these dates, but, and then once that period is closed, then the creditors that file after that, they don't get anything. But usually the creditors are watching those kinds of things, so they usually are the first to respond. And then once you do that, you take care of the property, you give out the stuff that's left. If you're going to sell the house, you put the house for sale, you sell it, you close it. And once everything is paid, whatever money's left, you give it to the beneficiaries. Once you do an accounting, and then you've asked the court to close it. It usually takes, because of the 4-month wait for the creditors, it usually takes at least 6 months to close a probate, sometimes longer, depending on what it is. But typically you can get them closed in 6 months. And that's the probate process. If you don't have a will, you do the same thing. Only difference is you don't have a will that tells you who to appoint. So usually you try to appoint the spouse, if there is one, children, if there are some children, or somebody that's responsible. And then you go through the same process. So there's really no difference between the with the will, without a will, other than the fact that the will specifies who gets what, whereas the statute specifies who gets what when there isn't a will. But the statute, like I said, pretty much does the same thing. It gives I think it's 75% of the community property to the spouse. Excuse me, all the community property, and then certain amount to the separate property to the spouse. It's, like I said, I don't want to get into the numbers, but that it pretty much gives it just to the family that is identified in the petition. Most people don't like probates because number one, they take a while, but also they're what's called public documents. So anybody can go look at a probate file. Once it's filed, it's public. It's available to the public. So that's one of the reasons why most people don't like probate. Another reason, of course, is people say that lawyers charge a lot of money, and some do. I'm not one of those lawyers. If it is a regular, just a house and personal property, I usually charge $5,000 or less, depending on what the situation is. I have not charged more than $5,000 for any probate, but I know people that have charged hundreds of thousands of dollars for probates. So it just depends on the lawyer you get. And that's pretty much probate in a nutshell. Obviously, that's a pretty quick overview, but that's the way really it is. That's how it really works. Let me see if I can.
There was a question. Is there a time limit for the executor to disperse the estate to the parties mentioned in the will?
No, there's not a set time, but he or she can give disbursements as you go along if they know that it's not going to go over the amount that the creditors are claiming. So they can make intermittent disbursements if they choose to. But it just depends on the person. Obviously, once the probate is closed, then all disbursements have to be made at that point. So technically, if you get it closed in 6 months, so in 6 months, all the funds have to be dispersed if you're going to try to close it.
Do you want to take more questions, or do you want to wait till after a couple more slides?
Let me see. No, I'll go ahead and take some questions. Most of the other stuff is dealing with community property stuff. So go ahead and ask
Okay,
questions.
Gertie is first, and then Cynthia and Jody. Gertie direct messaged me. Gertie, do you have your question?
I already had my questions answered. Thank you.
Oh, wonderful. Okay, good. Okay, Cynthia Grayson.
Yes, I have two questions. Harold, are you able to recommend when someone may have property or issues out of state? Are you able to recommend attorneys, like, let's say in the Los Angeles, California area? My cousin who lives in Oakland is having problems finding a lawyer in Los Angeles, and she needs to contest her mother's will. She has a special needs older sister who's now, I guess, probably about 69. And her mother left in the will that after she died, that the sister could remain in the house until she died. But she lives in Oakland and she needs to move her special needs sister where she lives. She says, because she can't find caregivers to live in the home with her. So,
So what does he need to contest the will?
because in the will, the mother said that she is not to be removed from that home, and that she is to remain in that home until she dies. That's what's in the will. So
Okay,
the
well-
attorney said to her,
Have they filed the probate already?
they didn't have probate. She had a will. They didn't go through probate. This was in the will.
That doesn't matter. She has to transfer the property. So if they haven't filed probate, sometimes instructions can't be carried out.
Right.
And if she's not able to stay there by herself,
No.
she has to be moved. But to answer your initial question, do I have no lawyers in LA? Unfortunately, I do not.
Okay.
I can, there's people I can ask, but I don't know of anybody off the top of my head.
Okay, because I trust you.
But you
and
don't- you
that's
don't
why I
really-
was asking, because she says she's contacted numerous lawyers and she's having a
Yeah.
very difficult time finding, someone. So,
Yeah, but if California is like Washington, you don't really have to have a lawyer in the city. Because I can do probates anywhere. And now
oh,
I think they let you do out of county probates even in King County. So that's what it is here. California law is a little different, so I have to always qualify that.
yeah.
They may do the same thing. So you don't need a lawyer in LA. You can get a lawyer as long as they feel comfortable doing it. They can do it probably.
Okay, I'll have her check that out because I think she checked with the lawyer locally and there in the Oakland area, and she was told that she was going to need somebody in Los Angeles. So,
Yeah,
but
and that may be the case, like I
Okay.
said, but I don't know
LA,
that. to be-
it's about the dollar, so everybody got to make some money. So, so that's where we're from. But okay, so I will. I'll have her. Well, that's what the problem is she's having right now. She just can't
Okay.
find someone down there. So anyway, okay, but I will let her know that she may not need to contest the will if like you said, she needs to move her sister. Go ahead and move her sister.
Right.
Okay. All right. Thank you.
Next question? Or was that it?
Yeah.
Jody is next.
Is it my turn?
Yeah.
Okay. Going back to my 9 kids, my 3 minor children, we talked about all the money stuff in a will. Do children go in the will and what you're going to do with your minor children? And like most of my children are special needs, so I'm also figuring I have to do some special stuff to make sure that they're provided for when
Right.
we're gone. But it's why I've avoided a will all my years. Is I don't know what to do with my minor children when I'm gone.
Yeah, well,
Not in the will, or is that just?
yeah,
something-
you can do that in the will. So you'd have to, when you say minor, how old are they?
10, 12, and 13.
Okay, yeah, so you'd have to appoint a guardian for them, and you can do that in your will. Then you would probably have to have a situation and this is where life insurance could help. But if you have enough assets, you put it in what's called a testamentary trust for them. So you appoint the guardian. The guardian gets the money from the trust that you create in the will. And then they take care of the kids according to your instructions. And then, you know, it's best to have something to have so that they can, you know, provide for the kids, not have to come out of their own pocket. So this is where life insurance would be a good thing to help with that if you don't, like I said, have the assets to do it.
Yeah, these are also my adopted grandchildren, and they
Okay.
get adoption support. And I'm also figuring out how I would because their adoption support ends when we die.
Right. But yeah,
So I don't, there's a lot of
Yeah.
things. There's a lot
Yeah.
I don't like. I am committed this year. My resolution for 2023 will be to get a will.
okay. Well,
It's important, isn't it?
that's good. Yeah. Well, like I said, you can at least tell people what you want done, and that's the key for a will. And when you have minor children, you do need a will. Next.
Christy is next.
Hi. Thank you for being here, by the way, and thank you for all this information. I'll probably
Sure.
be contacting you later just for personal reasons. But I heard you mention you were going to talk about common property interests or whatever next. So I think I'll wait on my question to see if you cover that.
Community property,
Sorry,
you mean?
Community, yes. I said common, but yes, community property.
Sure.
I forgot to lower my hand, so sorry.
That's okay.
Well, I'm gonna read the one in the chat from Grandma Rose.
Okay.
Can the last testament also include the final wishes? Like, I want my ashes to be scattered to many islands. Can I make that leftover money only for flights and hotel stays? So can you specify money for certain things?
Yes, you can.
Okay.
You can also do it in a separate writing, but you can do it in the will also. So you can say in the will, I've left specific instructions about my burial on another document, which is incorporated by reference into this will and attached to this will. So you just have to make sure it's with it. So everybody knows what you want. But you can do it in the will or you can do it in a separate writing. And that's one thing I didn't say. When it comes to personal property, even though you say, okay, my kids want, I should split all the personal property that I have at the time. And remember, personal property is anything that's not real estate. So cars, clothes, artwork, coins, all that kind of stuff. You can write out in a separate document and say, Johnny gets the car, Joey gets the truck, Sally gets the boat. You can do all that. And you can say in your will, and I have already set forth who gets what in a separate writing that's incorporated by reference here. And so that way you can do it, you can do the handwritten thing, because like I said, you don't really need a will for personal property. You just need to know where it's going to go when it's all said and done. A lot of people don't delineate what they want to go to where. So the kids decide that. But if you want to decide that, then you can do it in a separate writing and attach it to the will, or you can set it forth in the will. The reason why you don't want to set it forth in the will is because, I've done my will 4 different times. And so I don't own some of the stuff I had in the first will. So it's best not to do it in a will because you don't always own it at the time of your death. And so it's best to do it in a separate writing so that you can change it and then you don't have to change your will. Because if you sell all your artwork and you have in your will, my artwork goes to so-and-so, it's a dead gift, basically, because there's nothing there. And you probably should change your will. But if you do it on a separate writing and just say, I instruct the executor to give the property according to the writing that's attached and referenced in the will, then you can change that all you want and you don't have to redo the will. It's a lot easier to retype a piece of paper than to have to go through it doing a will all over again.
And then
So-
Harold, what happens if you're paying a car note and you die, and in that writing, as you're saying, maybe you say, I'm gonna leave this card to my son,
Right.
does he,
Have to pay
because
the
the
note?
contract and agreement is between you and whoever the loan is through, can he or she just pick up, your children pick up paying the car note, or are they gonna have to have that redone or reworked?
I think initially they can just begin to carry it, and then they can work out something with the bank once they, or I shouldn't say the bank, because it's not always banks who lend the money to buy cars nowadays, but whoever's the lender, they can work out something. But generally speaking, if you die, then the debt travels with the personal property. So if there's a loan on the car, it's going to have to be paid by the person that takes it over.
Okay, all right, thank you.
Mhm.
And
Any
then
other
there
questions?
was, just regarding the separate piece of paper, someone said,
Mhm.
does it need to be notarized as well?
Nope.
Okay,
Nope.
that's good to know. Thank you.
Mhm. So I kind of went through the probate process pretty quickly. Like I said, the ways you can avoid probate are through the trust, creating a trust. Trusts, I don't do trusts like trusts per se. I have done what's called testamentary trusts that are included in a will, which means that they don't come into effect until after I die. Matter of fact, when I did my first will, my kids were all minors. So I had a testamentary trust in my will to take care of my kids in the event that my wife and I both died. And then I had to, I used insurance to fund that trust. And then the relative that was supposed to keep them, thank God that didn't happen, but they would at least have money because I had 4 kids, and that would have been a pretty big burden to take for anybody to take on. So that's why if you're going to do a trust, you want to fund it so that people can have the money to take care of it. But you avoid remember, the reason why you have to do probate is because the person who died can no longer sign anything. Okay, I know that sounds simple, but that's the way it is. So you have to have the court appoint somebody to act in the stead of the person that passed away. If you want to avoid probate, you give everything away while you're alive, so there is nothing to deal with in the estate. That's one way to avoid probate. The trust is one document that does that because, like I said, you transfer everything into the trust, and it's no longer in the name of the owner who bought it. Okay? That's why you can avoid probate. Now, most people still file probates with a trust, but they in the probate they say, appoint this person. And the reason I think they do it because sometimes the people that they're dealing with want letters of administration that the court issues that gives the person that's been appointed as the executor the ability to transfer stuff. And sometimes the trust, because even though it's transferred, you can't transfer it. Well, I guess you could if the trustee is not the same as the beneficiary, then you would probably need to go and do a probate. But it gets complicated. But the bottom line is, if it's transferred out of the name of the owner, then you don't have to transfer it at the time of their death, and that's how you avoid probate, as they like to say. And again, the transfer on death deed also avoids the transfer of property through probate. You can transfer that before you die, and that's a good thing. A lot of people were doing quitclaim deeds, which actually does work too, because you execute the quitclaim deed, but it's not as clean because you have to hold the quitclaim deed until the person dies. Then you can file it, and it'll operate and to transfer the property. But since they created a transfer on death deed, then you don't have to do that anymore. You can just use that kind of a deed. I mentioned this once, but I didn't really get into it too deeply. But if you don't have more than $100,000 in personal property, and you don't have any real property, and I'm on slide G, I think it is. Yeah, there you go. Then you can use what's called a small estate affidavit. And you, in that affidavit, you state, and I should have given you guys one of those, and I may attach one later. I haven't done that a lot, but I do. I think I have one or two around on my hard drive. And you can take that to the bank, and then they'll allow you to move money out of accounts or whatever it is that needs to be done. Sometimes the bank will make you do that even though you're on the accounts. Banks can be just difficult to work with sometimes, and you probably all know that. But bottom line is, if you need to do it, you can do that. That's called a small estate affidavit, and that way you don't have to file a probate. Again, it has to only be personal property, and it has to be less than $100,000. If it's more than that, there's a dispute as to whether or not you have to file it, but most likely it's probably best to just go ahead and file it if that's the case. Community property, just real quickly, next slide. Community property is a statutory created thing in the state of Washington, and I think there's 4 or 5 other states that have community property. California, I know, is one. I think Texas may have it. Louisiana may have one, and I can't remember the other one. But what it does is that it means that once you're married, you and the spouse own the property equally. It doesn't matter if one works and the other one doesn't. The marriage creates a joint interest in community property. And so what that means is if the person dies, one of the spouses die, then the other spouse gets the property because it's jointly owned by the community. You can do what's called a community property agreement. I think initially when I first got married, I did a community property agreement converting everything we get from this time after is community property, so that every property I have belongs to my wife and vice versa. And that's pretty much all I need to say about that. You probably heard, especially, and this is not in here, but you've heard of what's called prenuptial agreements. People who have a lot of assets a lot of times do what's called a prenuptial agreement. And what that means is that they try to divide the property before they get married so that there's no confusion on it. That doesn't really have anything to do with estate planning, unless, of course, one of the spouses die. But it does come in if one of the spouses die and there's a prenuptial agreement, because usually a prenuptial agreement will affect the normal community property agreement or arrangement that's statutory. So just keep that in mind. That's probably all I need to say about that. Let's see here. Oh, powers of attorney. Let's go to I think that's actually the last slide. And we've talked about living wills a little bit. And living will, like I said, is really the wrong name for that, but I don't know where that came from. But anyway, it's really called a healthcare directive. And basically those tell medical providers what to do in the event that you can't become incapacitated. You can do the same with a power of attorney. So there's 2 different kinds of powers of attorney. Well, actually, there's 3, actually. There's one that deals only with financial issues, as you can see there. And then there's one that deals with financial and healthcare issues. And then there's a power of attorney that's just what's called a general power of attorney, which means that once you sign this power of attorney, it comes into effect immediately. Then there's what's called a durable power of attorney, which doesn't come into effect unless the person becomes unable to take care of their needs or their personal property or financial situation or whatever they can't take care of. So a durable power will kick in once they need help and they can't do it anymore. A general power of attorney kicks in immediately, and the person can start doing things for the person that appointed them as, and the term is attorney in fact is what the power of attorney does. That person that has a general power of attorney can start working on their behalf right away. These are only good as long as the person is alive. I'm talking about the powers of attorney. Once they die, powers of attorney terminate. And usually it says that in the powers of attorney. A lot of people get confused and they say, well, my mother's dead, but she gave me power of attorney. It doesn't mean anything anymore. That those things terminate as soon as the person dies. So just keep that in mind. So don't start doing stuff after somebody dies, because then you can get yourself in trouble and have to put assets back that you may have taken after they died just because you were the power of attorney. If you do a power of attorney and it's dealing with property, you should file it with the King County Records Department. Some people say you should file it anyway. I don't know if that's a good advice to just file it even if there's no property involved. The reason you need to file it if there's property involved, because you might have to transfer property in the name of the person that appointed you as the attorney in fact. So that's why some people, when you file it, that means there's public notice, but you usually have to give it to the bank. You have to give it to the insurance agent. You have to give it to so-and-so. You have to give it directly to the people that you're going to have to deal with anyway. So unless they're going into the records and looking it up, they wouldn't know that it was filed anyway. But that's important if you transfer a deed, because the King County records, and I'm thinking of King County, obviously, if some people may be in other counties, they will see that there's a power of attorney on file, and they know that you have the ability to transfer property on behalf of the person that you're transferring the property for. That's really all I have as far as slides go. But if you have more questions, we can do that. And I think what we have about another half an hour, I think, right?
Yes, we do. And we actually have 2 questions already ready for
Okay,
you.
go ahead.
Christy, do you want to go? And then Grandma Rose?
Okay, yes. So, community property. My boyfriend and I are not married. And I think, so I'm trying to simplify this. We do have a durable power of attorney, but it does not include the property. It's my understanding that somewhere in the deed, it states what will happen to the property if something would happen to one of us. According to
Is there right of survivorship in the deed?
That's what I don't know. I don't remember hearing
Okay.
ever about that, and that was my
Okay.
main concern, is that because I wanted to make sure it goes to me instead of her son. One of the problems that lies, I think, in this situation is he's the only one on the loan. But if you look up King County records, lo and behold, my name is the only one on the house. I understand though that it's the mortgage is owned by. I mean, our house is owned by the mortgage until we pay it off. So
So what's the question?
So my question is.
Well, let me
you
start with you started with community property. Okay, first of all, you don't technically have community property because you're not married. So that's a marital creation. So if you want community property, then go ahead and get married, and then that'll start the community property clock right away.
Okay, when I had said common property earlier, that's what I was thinking in my head, is like, well, we're a community property state, correct?
Right. So
So
common
Okay.
property. So if you're not a community property state, you're what's called a common law state. And common law is, they have rules similar to community property, but they're not quite the same. So every other state that's not a community property state, which I told you about 5 of them, is a common law property state, but we are not one of those. We are a community property state. So when I say we, the state of Washington. So if you want to create community property, you have to get married. If you want to transfer the property into your name, then you guys need to do either a deed, execute a deed with a joint, with a right of survivorship in it, or joint tenancy deed, which says that if I die, the property goes to the other tenant that's on the property name, or you should just deed it in the will, and therefore it will go to somebody that's listed in the will. So that's the way you can make sure the property goes to the right people. But as it stands now, if your name is on the deed and his is not, then it doesn't really matter what the mortgage says. It's the deed that controls.
I'm in a good sitting position right now then. If nothing were to happen to me.
Right.
But so is this the same deed that you were speaking of earlier in
No.
the, okay.
No, the deed
So
that I'm talking about is the deed that did you buy the house before you guys got
we
together?
we did it together, but like I said, the loan is in his name. We have,
But
I
you
mean-
said the deed was in your name.
yeah, right. We both signed paperwork together for the
Right.
house. We're not married, but his is the only name on the loan. My name's the only one on the house. How that happened, I don't know, but hey.
Yeah, okay. Well, if you want to fix it, then you can fix it. You can add
So
him to
the-
the deed, and
Okay.
he can add you to the mortgage. But yeah,
So at this point, because like, again, when I look on King County website and look up our house, I only see my name. I don't know if that was an error on the King County part and they just didn't put his name in. It's too long, but I know all the owners before it had both names.
okay. Now, so are you looking at the deed or are you looking at the tax records?
Tax records.
Okay, that's not it either. Okay, so
Oh, okay.
if you go to King County parcel viewer, okay,
Yes,
put your tax ID or your address, whatever.
yes, that's what I'm looking at.
Okay. And in that, it says property report. You click that. And at the bottom, it should show the transfer. Doesn't always show it, but shows the transfer of property history.
Okay.
And if it has a transfer of property history, it also has a clickable deed that you can pull up. That's the deed that you signed at the time of the purchase of the property, and that will tell you whose name is on the deed. Okay,
Okay.
all right,
All right. Thank you.
you're welcome. Next question.
Grandma Rose and then Jerry Gates.
So, I just have a question about like, those, those living wills that you do when you, go in for surgery and stuff.
Yep.
Can those be held as, evidence for when like somebody passes away, that this is really what this person wanted and this is who this person wanted in charge? If there's, because I seem to be dealing with a bunch of procrastinating parents that don't want to actually discuss death, like it's not gonna ever happen to them, but they're like ill.
Right.
And
Well, everybody does that though. But no,
yeah, but
let's get back to what you said. So living wills, remember,
yeah.
the living wills, that's a bad name. It's really death instructions or what to do in the case of treatment. Living wills have nothing to do with the will. Okay. And like I said, they're better called healthcare directives, but not they have, even though it says they're a living will, they have nothing to do with the will. So even if you say in the living will that I want Johnny to be the one that makes the decisions for my health care, right? That's what you're referring to? You still there?
Yeah, I'm nodding my my head, sorry. Yes.
Okay, I can't see it for some
No,
reason, I can't
yes,
see all the
yes, I-
faces. So, okay, then that doesn't have anything to do with your will, okay? So throw the name living will out and call it healthcare directive. That'll help you better understand what it is, because it's not a will, has nothing to do with the will.
It's
It has
not
to do with,
evidence, right? To
no,
bring to court?
no,
No, okay, okay.
I mean, if, let's put it this way. If you didn't do a will, okay, and somebody said Johnny should be the one that makes decisions, Johnny can take that to the court and says, well, I did this for her. I should also be the administrator of the estate. Now, the court doesn't have to take that as, okay, yeah, well, yeah, that's the last word. He still has to know that first Johnny doesn't have a criminal history, okay? Because it doesn't matter, and you can appoint Johnny, he can be a 10-time felon to be the person that makes decisions about your health care, but Johnny cannot be an administrator of the will if he's a 10-time felon, or if he's just a one-time felon, okay? So it's not the end-all be-all, but the court might use that to make a determination on who should or shouldn't be, but it's just one piece of evidence. It's not the end of the story, okay? Does that help?
Yes, sir, thank you.
You're welcome. Next question.
I believe the next question
it
is,
me?
oh. No,
Labrie?
it's not, it's Jerry Gates. She typed it. Sorry.
Oh, okay.
She said, I have many questions about these topics. I lost a child to domestic violence. I am the legal guardian for my grandchildren. I was her power of attorney until her time of death. I need to know how to get authorization to her financial institutions. Can I connect either you at a later date on this topic and a couple others? Is there a charge for this consultation outside of this workshop? Thank you for your time.
Okay. Initial consultations, there are no charges. If I have to do work, then of course there'll be a charge. And it depends on the work that has to be done. So I can't tell you, well, it's going to cost this amount of money. It just depends on what needs to be done. So yeah, no charge for initial consultations though. But yeah, you can call me or email me about your situation at a later date if you want to.
Okay, then it's Gertie and then Vancella.
We own a house. My name is not on the house because I had some very weird reasons, but I didn't want to be on the mortgage.
Okay. No,
would it-
okay. No, wait. You said two different things already. You
Okay,
said you're not on the house, and then you said you're not on the mortgage. Those are two different things.
oh, so
So
I'm
you
not
can,
on
so
the,
you can be on the you can not be on the mortgage, but you can still be on the house if you, were you married at the time you bought the house?
we are married.
No, were you married at the time you bought the house?
He bought it before we met.
Okay, that's why you're not on the property. Okay, now go
Okay.
ahead, finish your question.
We have been married for about 13 years.
Okay.
In case something happens to him, should I be added to the house now? Would that be a better idea, or is that all common property, or?
Well, he bought the house before you were married. It's actually separate property.
Okay,
So if he wants to add you to the house, he can do that. Now, I hate to get too deep into this, but if you've paid some of the mortgage, if you've paid some of the expenses of the house out of your own income since you've been married,
I didn't.
okay, then that property is still his separate property.
Oh, okay.
So if you want, you guys need to sit down and talk about him adding you to the deed of the house, which is the ownership part of the house. Whether he adds you to the mortgage, that's doesn't matter, but the deed matters, okay? So if
Okay,
that's what you want to do, then that's what you need. You can do that without a lawyer. I mean, obviously you can use a lawyer, but you just need to, he needs to either add you, quit claim the property from his name to your name and his name together. And that's all he would have to do to get your name on the deed. Okay?
and if something would happen to him and I'm not on the deed, is it my responsibility to keep paying the mortgage or pay it off and I own the house?
No, you wouldn't own the house because, well, only you would have to, he would have, does he have a will?
No,
Okay. Does he, do you guys, does he have children before?
he has
came
no
in?
children.
Okay, all right. So that's probably the property would go to you because you're his current spouse. But there is some uncertainty there. So the best thing to do is to add you to the deed. To make sure that it would go to you. If he wants to do a will, then he can transfer the property or say that the property goes to you in the will or whatever. That's not really necessary if your name is on the deed. But you can do both if you want to make sure it's all clear. But are there any children at all of part of the union as well, or no?
No,
Okay, so it's just you and he.
yes,
Okay, all right. So yeah, just tell him to just add your name to the deed. That
Okay.
should solve your problems.
okay,
Yes,
yeah, I
and
have.
in the event, I'm sorry, I didn't mean to talk over you.
Okay.
But in the event that he did pass away, you would be responsible for the mortgage. It's not a reverse mortgage, is it?
No,
Okay. So yes, you would have to pay the mortgage if something happened.
okay.
So if that's a question, and it sounds like you're not working outside the house, is that true?
I was working full-time, but I'm raising our 4-year-old grandson.
Okay,
So
So you
now
might-
I'm not really, no.
yeah, so you might want to have him get some life insurance then. And that way, if something were to happen to you and you had to pay the mortgage, you would not have to go out and get a job immediately to do that. So those are the steps that you can take, and those are pretty easy steps to take. Okay,
Okay, thank you.
you're welcome. Next question.
Voncella has a question.
Okay,
The question that I had power of attorney, and then I had another thing about me taking care of his business once he dies.
mhm.
And so what I want to know is, how can I find out if he had life insurance? Because he told me that he was hooking life insurance up, but I don't know how to find out. He didn't never tell me. He didn't never tell me
Okay,
what the
I
company
gotcha.
was.
Okay, did he tell you who the agent was?
No,
Okay.
because
Um,
listen, after
uh-huh.
he did this on his own, and until I became power of attorney, I didn't know that he was really. He had cancer, but I didn't know he was dying that quick.
I see. Okay. That's a tough one because the only way you're gonna know if he's got insurance is you gotta go through his papers. If he didn't tell you.
Yeah, and see when I went to the bank to see, because I think they were drawing the money out of his bank account.
Okay, well, that's one way to find it.
Yeah, but the problem is now the bank don't want to tell. I went there and asked for his bank
Statement.
statements,
Yep,
and
They
they
won't
were
give it
supposed
to
to
you?
put my name. They were supposed to put my name on that account,
but they didn't.
but they didn't because he died so quick.
Okay. Are there any children involved?
No,
Okay,
my children.
but they're not
And what
his?
he did was he made a tape before he died.
Mhm.
But he has a sister.
Okay. Are you guys married?
No,
Okay,
because
All right.
he wasn't my boyfriend or nothing like that.
okay, so
But
you guys were just friends.
yeah, he was a
Okay.
brother. I call him a friend that's closer to me than a brother. He helped me raise my kids.
Okay. Well, so is anybody on that account?
No,
Okay. Does he have any real property? A house?
he has real property, but that I don't care nothing about that. That goes to his sister.
Okay. Well, technically, it all goes to his sister, since you guys
Oh,
weren't married.
Even if he
Unless he
made a
has-
video, even if he made a video saying that I get the money out of the account.
Well, that might help, but I mean, there's a lot of more details that you're gonna have to go through, and so we're probably gonna have to meet and talk about it, but that could change that part of it, because that's personal property, but yeah, I mean, it's gonna take some unraveling, if you will.
Yeah, it's a mess. And
Yeah.
I'm going to tell you, I have
How long ago did he
dealt
die?
with lawyers. It's been a year.
Okay. No probate started?
No.
Okay. Okay, well, yeah, if you want to call me and we can talk about it more detail, that's fine. Because it's probably too complicated to go into now.
Oh, it is.
Okay, well, we'll be giving the information along with the video and the forms after the session, so you guys can contact Harold as you see fit. I have to hold the rest of the questions because we need to wrap up. So Rose, is it okay if I send him if I send you the information and you can send these questions over? I don't know if she can see me.
Oh, I don't
Gotcha.
have any more questions.
Oh, it was in the chat. I'm sorry.
Oh, that's just, I would like a life insurance workshop.
Oh, got it. I'm sorry.
That's what that was saying, because I'm
Wonderful.
this is right on time, Mr.
Yeah.
Franklin. So thank you so much.
Well, we
You're
can
welcome.
definitely talk with Cynthia and get that one added to it.
Oh,
I just
yeah,
want
I have someone that sells insurance, life insurance, and he'll be happy to come. He'll love it. So, and Harold, I just want to tell you, don't forget to also send us the information about small estates.
Yeah,
If you get a
I'll send the
for
form.
that.
Yeah.